So good morning. Evan, are we on? Okay. Good morning, everybody. Thank you for coming out. Help yourself to breakfast. As you see, we just have a nice, small, little intimate group. So just real quickly, I am Joan Renner. I met most of you already in the room, if I did not already. Good morning. I have the honor of serving as the president of Scenic Rivers Land Trust, and I enjoy working with the organization. If you don't know much about us, and this is your first time getting to know us, we are a 501c3, and I'm sorry, but I have to look at my notes for a minute, that we work with organizations, partners, and people to protect our natural and scenic areas in probably central and southern of Anne Arundel County. We have over 3,200 acres under conservation that are under our watch currently, always looking to expand, and why we like to have this meeting so that we can reach out to new partners, new people, you know about the process, and we're here to help, and we always like working with landowners and other organizations in the area. I'm going to just do a quick introductions, and I do want to let you know, as you can tell, the event is being recorded, and we will just to share on our YouTube channel. Nothing going viral, don't worry, but we like to have it available for future reference for people who want to learn more about us and the process. So I gave you a quick introduction of myself already, and I want to introduce briefly our other speakers. So first is Sarah Knebel. She is the executive director of Scenic Rivers Land Trust, and she has been with the organization for 7 years, and in different capacities. She's not always been our executive director, but we were very happy that she moved into that position. She has worked with funding programs to provide millions of dollars to landowners to conserve their land through the conservation easements. Our next speaker is Kristen Maneval, and Kristen is a current board member, and she is the senior counsel at the Maryland National Capital Park and Planning Commission. Previously, she worked for 10 years as the Assistant Attorney General and Senior Counsel for the Maryland's Office of Attorney General, representing the Maryland Environmental Trust that we have representatives here for, and which is a statewide land trust. And then, last but not least, is Ben Wechsler. He is our counsel, and he is member of, I'm going to try to get this, law firm of Yumkas, Vidmar, Sweeney, and Mulrenin. Pretty close. I knew the last one I messed up. Sorry about that. Or we can say YVSM for short. Ben has over 20 years of experience in land use, environmental, and natural resource and real estate matters, and he is a previous board member of Scenic Rivers Land Trust. So welcome, everybody. I hope you learn a lot. I am going to ask you to hold questions till the end. We do have a period of time for Q&A. So we can answer all the questions at the end, but let the speakers get through the material, jot down your notes, and then we'll get back to it. I'm going to turn it over to Sarah, who is going to start us off. Thank you.
Thanks, Jen. Okay. I'm going to take this off. Okay, so I am just going to run through a couple of framings for this conversation. So first, I always have to thank our sponsors for funding this event. So BG&E, Mars Foundation, and the Paul and Maxine Frohring Foundation. We are so thankful for their support for this event. And what we're going to run through today is just, why do we conserve? Then I'll hand it off to Kristen and Ben to run through conservation easement fundamentals. Joan will go through some tax incentives. And then I'll hop back in and talk about some funding programs and run through some examples of how a conservation easement could work. And then we'll end with, we'll have about 10 minutes for questions at the end. So why do we conserve? Why, as a charitable nonprofit, why do we do this work? So, our forests and farms and wetlands provide us with food and clean air and clean water. They help, forests and wetlands help the Chesapeake Bay, and our name is Scenic Rivers Land Trust. So even if we can't access the land, the public can't access a property, that private protected forest is still doing the public good by providing clean air and clean water. So, what type of land are we talking about? How big are we talking about? Usually for scenic rivers, we have a 10-acre minimum. There's 3 caveats to that. So one, if there is public access on the property, then we'll go smaller. So say, water access or a trail, community garden, something like that. The second caveat is if there's a rare, threatened, or endangered species on the property, and we think that habitat on what's being conserved, that species could survive. And then the third caveat is if that small property is right next to already protected land. So we're adding to a larger conserved area. And of course, we want it mostly undeveloped. You could have a house or 2, depending on the size of your property. And we're mostly looking for, forests, farms, wetlands, streams, meadows, not shopping malls or really dense townhouse subdivisions. And, if it's in a government priority area, it's a lot easier for us to get funding and also convince the IRS that it's adding to the larger conservation goals of the state. So we always look for that. And then the last and very important aspect is that there's an interested and willing landowner. So today we're talking about voluntary permanent conservation easements, which is a very different beast from regulatory easements. So regulatory easements are done when the government is requiring you to do a conservation easement. So say a developer is cutting down a bunch of forest to build a subdivision, and county code is requiring them to conserve a portion of that property for forest conservation. So that type of regulatory easement is not what we're talking about today. We're talking about voluntary. The landowner wants to do it. There's no obligation to the landowner to do that. So with that, I'm going to hand it over to Kristen, and she'll run us through what is a conservation easement.
Okay, good morning, everybody. I've met some of you all, but look forward to meeting others of you as the day goes along. First of all, I want to start with some themes that we want to leave you with at the end. So it's a good idea to introduce them at the beginning so you can be thinking about them. Conservation easements protect land from development without having to relinquish ownership. So a landowner can retain fee simple ownership in a property and yet convey a conservation easement, protect the property by doing so. Second, as you'll learn today, these can be very valuable tools from different points of view, from conservation points of view as a way to protect the land in perpetuity, but also from estate planning and from tax planning points of view. But if you or a client decides to pursue a conservation easement, be sure to surround yourself with a team of professionals that's really competent. And by professionals, that might be an attorney, accountant, appraiser, tax advisors. These are very nuanced sections of the law, so you want to have people who have done this before and know where to go for the right resources. And as we'll hear later, there are really attractive tax and other benefits for entering into conservation easements. The most attractive being the federal income tax benefits. So if you or your client is interested in that, then be sure to follow the rules, because these easements are really under view by the IRS. They are watching, so it's important to do everything just right. So we'll start out by talking about easements, and I know we have a number of lawyers in the room and actually easement professionals, so this won't be new to you, but just for baseline, to talk about easements themselves, an easement being a right of use by one property over the property of another. And so they're created by a grantor giving something to or for the benefit of a grantee. They're memorialized by a document that's in the land records, recorded in the land records, running with the property, binding on successors and assigns. And up in this blue box here, you can see some types of easements that you're probably already familiar with or you've heard of. Utility easements, ingress, egress, access easements, stormwater easements, scenic watershed easements. So we could take, for an example, an access easement. Say someone wants permission to go through somebody else's property to reach a portion of the first person's property. You'd have the benefited property and the burdened property being the land through which the driveway is running, the benefited property being the one at the end receiving the access. And then the burdened property, that owner is essentially agreeing to various restrictions. I'm giving you the benefit of going through my property in this 10-foot wide corridor, and I agree as the burdened property, I won't put a barn right in the middle of your path. I won't put a house there. So you're agreeing essentially to restrictions. And now we can move into conservation easements. Conservation easements are a relatively new tool if you think about the long history of property law that goes back thousands of years. They just date to a few decades ago. In fact, Scenic Rivers just had accepted its first easement in 1989, so that's within range of what many of us can remember. We refer to these as deeds of conservation easements, and like the easements we just described, they share those aspects. They're recorded in the land records. There's a grantor, a grantee. They take the form of a deed. They run with the land. They're binding on successors and assigns. But unlike the access easement that I just described, they don't burden one particular property to benefit a specific other property. Instead, they benefit the public in general. So conservation easement is essentially a transfer of development rights to a land trust or a governmental land trust to preserve conservation values of the property for the benefit of the general public. Again, it's an agreement to restrict doing certain things that you might otherwise have the ability to do, often for an environmental or historic type benefit. Now, we should talk about what makes a conservation easement under Maryland law. And here we want to understand that the Maryland Annotated Code, the real property article, this is where the legitimacy of conservation easements in Maryland comes from. At section 2-118, which, I brought my text itself, but I also brought a printout in case my book wasn't up to date. So a restriction can create an enforceable property interest under Maryland law if it is for one of 8 purposes, and these are all set out in the code. And so to be a valid conservation easement in Maryland, you need to have at least one of these purposes. A lot of properties will have more than one. And so I'll go through these restrictions for you. Again, it's a restriction on doing something. So it's a restriction on constructing, placing, developing roads, buildings, signs, billboards. A restriction against dumping or placing soil or trash on a property. A restriction against excavating, dredging, soil, rock, etc., in a manner that affects the surface and topography. A restriction against destroying trees, shrubs, other vegetation. A restriction on the surface use, except for preserving water or land areas. Number 6, a restriction that would affect drainage, flood control, water conservation, erosion control, and conservation, or fish and wildlife habitat. Number 7, a restriction on to preserve solar energy devices exposure, so exposure to solar panels. And number 8 is the catch-all, which is other acts or uses having any relation to the preservation of water or land areas. And the code also goes on to say that if an easement, a conservation easement, is executed in the same manner as required of other deeds, which are set forth elsewhere in the real property article, then it can be valid in Maryland. Now, this session was open to real estate agents in addition to other kind of property professionals. So I did put in a tip here for real estate agents in case we have any with us. But for those people who are title searchers or others, this is good for you to know too. This is really on the topic of conservation easements that already exist and they're already in the land records. So Scenic Rivers has been working since 1989. Maryland Environmental Trust since the late 1960s has 1,200 plus easements around the state. So we know there are a lot of properties out there that already have conservation easements on them. So what happens if one of those properties changes hands? The fee simple interest changes hands. Well, as we said, the conservation easement would survive because it's binding on successors and assigns, but there are certain duties that have to happen if a seller of a property can serve with a conservation easement wants to sell their fee simple interest to a buyer. So what needs to happen there is before entering into a contract of sale, the seller needs to give the buyer a copy of the recorded conservation easement and the notice required by another section of the real property article, which is 10705. And the notice is an official notice to the buyer telling them that there's a conservation easement on this land. And the notice text is right here in the statute. It says, essentially, the property is encumbered by a conservation easement affecting uses of the property. Maryland law requires that the seller give to the buyer a copy of the conservation easement on or before the day that the contract is entered into. And so the buyer should review the easement carefully to understand the buyer's rights, responsibilities, and obligations, including a requirement that after sale, the buyer must inform the holder of the conservation easement, which is the land trust, of the sale of the property. So you can imagine a couple scenarios there. What if the seller didn't know about this? Suppose the buyer doesn't get a copy of the easement and the notice before entering into the agreement of sale for the fee simple of the property. What would happen? The buyer in that case is entitled to rescind the contract at any time before or within 5 days of eventually receiving the copy of the easement and the notice, and can point to the fact that they didn't have that easement as the reason for rescinding the sale and needs to notify the seller that they did that. But if the buyer does get the copy of the easement and the required notice before entering into the contract of sale, then the buyer can't rescind the contract of sale just because of the easement itself. And then many of the conservation easements that are already out there in the land records, they contain a clause that will say when the fee simple interest is transferred in the deed that accomplishes that transfer, there should be a separate paragraph about the conservation easement. And the purpose of that is to just highlight it for the reader, for the title searchers, so that that conservation easement doesn't get sort of lost over time in the land records. Now, we talked about easements restricting what the landowner, the fee owner, can do with the property. But of course, you know, no one's going to be persuaded to do a conservation easement unless they can retain certain rights too. So what kind of rights could you retain even if you do grant a conservation easement? Here's just some of them that I picked out. The right of privacy. A lot of people are under the misapprehension that if you grant a conservation easement, then the following Saturday the public can come tromping through your property and looking around in your windows. But that's not how it works. You'd have to voluntarily grant public access if that were to be the case. Although you need to keep in mind that land trusts, the land trust holder does have the right to come in to do annual monitoring. The landowner can retain, as we just talked about, the right to convey the property, the right to hunt, fish, farm the property, timber, right to develop, as Sarah said, a limited number of residential structures, including ag structures, limited rights like operating a home office, and then private passive recreational uses. If you convey an easement, you can still go out and cross-country ski on your land, canoe, hike, do photography. All of those are still within your rights. And other rights that are not inconsistent with conservation values. And I'm going to hit that one a little bit later, so hold that thought. Another way to think about conservation easements is by what mechanism the grantor is incentivized to grant the easement in the first place. So one category that we can talk about is purchased conservation easements, where the owner is incentivized to grant the easement because they're being paid. And you might think to yourself, well, who's out there giving money for another person to conserve their property? But there are many federal, state, and even local programs to purchase conservation easements. And in those situations, the property would usually have to be part of or in the area of a larger coordinated preservation effort that's going on, like a large landscape initiative. And there are also large nonprofit groups that have money to buy easements. Some of the big ones out there are the Conservation Fund and the Nature Conservancy. They're usually looking at really large properties, maybe at the scale of ranches, not so much at the scale that Scenic Rivers would work at. And purchase price, how is that determined? Well, to determine what a conservation easement is worth is kind of tricky because it's a abstract concept. It's a piece of paper. How do you figure out what the value of not being able to do something in the future is worth? But the way you do that is through appraisals. You appraise the property as it currently stands, as it currently exists, and then there would be an appraisal of what the property would be worth after the various restrictions that the grantor and grantee agreed to were on the land. And the difference in the price is what we call the value of the easement, and that's what the landowner would be compensated for. Another type of conservation easement is the donated conservation easement. This is one that Maryland Environmental Trust works with almost exclusively. Scenic Rivers does quite a lot. In that situation, the landowner is not paid for the grant of the easement. They're doing it for some other reason. There's some other motivation that's making them want to restrict their property in the future. And some of those reasons may be tax benefits at the federal, state, and local levels, which we'll talk about. And then number 3, there can be a hybrid, which we call a bargain sale, where the landowner's being paid partially, but not fully to cover the full value of the easement as calculated by the differences in the 2 appraisals. It's a blend of a purchase and a gift. And in a bargain sale situation, to the extent of the gift, the landowner could be eligible for tax benefits. Okay, this is a preview of what you're going to see from Joan, but what makes a conservation easement a valuable tax planning tool? There are tax benefits, federal, state, and local, and some are more more attractive than others, I guess. At the federal level, there's a deduction, and from the income tax, estate tax, reductions and exclusions. State level has income tax credits, income tax deductions, estate tax, and state property tax incentives, and at the local level, county property tax. Getting into what is many consider to be the most attractive, the federal income tax deduction. If you're interested in pursuing that, you need to follow the Internal Revenue Code and the U.S. Treasury regulations to claim a federal income tax deduction. The code at 170H allows for an income tax deduction for a qualified conservation contribution, which is a contribution of a qualified real property interest to a qualified organization exclusively for conservation purposes. And that purpose must be protected in perpetuity. So each of those phrases there that are in red, those are terms of art that we can get into here. But on the next slide, we're going to just understand a little bit more about the qualified conservation contribution itself. Conservation contribution, and you can see in the word contribution that you're contributing, you're giving something. It requires an intent to donate. The donation cannot be what's called a quid pro quo for development approval, like Sarah gave in the example earlier, where a municipality or a county is telling you you must grant an easement. If you have to do that, you don't have what's called donative intent. You don't have in your heart, you don't have a desire to do this for purposes that are not motivated by an external factor. Qualified real property interest, it could be one of three things. We usually see the third one the most in red, but it is possible to grant an entire interest in the property, a fee interest, or a remainder interest after like a life estate. But what we talk about most is perpetual conservation restriction, which is otherwise known as a conservation easement. They are referred to as conservation restrictions up in New England. So talking about conservation restriction, this is coming right out of the Treasury regulations, and I put the site there. It's a restriction in perpetuity on the use which may be made of the real property. Qualified organization needs to be the holder of the conservation easement. Qualified organization could be a governmental entity like Maryland Environmental Trust, a land trust, Scenic Rivers Land Trust, for example. But a qualified organization, most importantly, has to have two elements. It needs to have the commitment to protect the conservation purposes of the donation, and number two, the resources, or whether it's funds or staff people, to enforce those restrictions. And here's just a side note that Scenic Rivers Land Trust has been accredited by the Land Trust Accreditation Commission, which is a national organization that looks over land trust in accordance with best practices in the industry. And so Scenic Rivers has passed and been approved as an accredited land trust, meaning we passed an outside organization's scrutiny, and that we successfully demonstrated that we have the resources and the commitment, as were the two elements of that prong. We have the staff, we have the money, we have the commitment to protect the easements that we hold in perpetuity. Conservation purpose. Now, for an easement in Maryland, we said that it had to meet one of the 8 restrictions that come out of the real property article. But if you're interested in also seeking a federal income tax deduction, you need to meet not just one of the 8, but also one or more of these 4 here. And these are going to be familiar to many of you, but number 1, outdoor recreation or education of the general public. It needs to be substantial and regular public access. Number 2, significantly relatively natural habitat for fish, wildlife, or plants. Number 3, historically important land area or certified historic structure. And number 4, an open space that yields significant public benefit, whether for scenic enjoyment of the general public or pursuant to a clearly delineated federal, state, or local governmental conservation policy. And there is a prohibition on inconsistent uses. And the last slide here before we go to Ben is about perpetuity. What is perpetuity? Perpetuity is a long time. We don't really know how many years perpetuity is. No, seriously, it's the concept is that these easements should last forever, and the land trust, as I just said, needs to have the ability to protect them forever. But we also need to, at the get-go, make sure that there's nothing out there in terms of prior documents on the land records that could potentially do a sneak attack and cancel this easement in the future. So at the time that an easement is granted, the land trust and the landowner need to take steps to see if there are any deeds of trust or mortgages that precede the easement in the land records which give the lenders power of foreclosure, because we would not want a lender who lent to the fee simple owner to be able to foreclose on the property, come by later, and wipe out subsequent documents, including the conservation easement. So it's important to have a subordination agreement. Other ways to protect perpetuity: in a really, really rare situation, don't even know if we've seen one yet, if surrounding circumstances change around the property, and it becomes impossible to uphold the conservation purposes, there's a possibility of going to court for a judicial proceeding where you convince a judge that it's becoming impossible to uphold the conservation purposes. And in a rare situation, very rare, an easement could be extinguished and the land trust be given proceeds to go out and buy substitute property to protect those conservation values somewhere else. And final note is that easements cannot be amended to weaken the protection of the conservation values. Turn that over to Beth next.
Good morning. So again, I'm Ben Wechsler. I am primarily a land use and environmental attorney based here in Anne Arundel County. Been involved with the land trust for years and years. I usually start this talk every year by asking the question, why is a land use attorney who represents developers doing land trust work? And very high level land use attorneys understand what can and can't be done with land. They understand the county, state, and federal restrictions on land, and anytime you're dealing with a conservation easement trying to extinguish development rights, you have to start with the question of what are those development rights. So as Kristen said, when you're kind of playing around in the conservation easement world, having a team of professionals who know their way around these things is important. And as far as the lawyers you run into, it's typically kind of land use lawyers like myself plus tax lawyers. The tax stuff, I tell people, I know a little bit about IRC Section 170H. I know enough to be dangerous. I also know enough when I need to call a CPA, I need to call a tax attorney, and I need to hire a very good appraiser. So a lot of this is, as far as staying out of trouble and recognizing problem areas, is knowing what you don't know and knowing when to phone a friend. So, picking up on the last slide Kristen had, subordination. This is a constant problem area. You would think that if you have a piece of property that is subject to a deed of trust, a mortgage, an indemnity deed of trust, and you wanted to do something really great, like put a perpetual conservation easement on the property, it'd be easy. Not necessarily so. Banks are very sensitive about anything that may impact the value of their collateral. And as a result, when you go to a bank and say, hey, we'd like you to subordinate your easement or subordinate your deed of trust to our easement, their typical response is either no, or go refinance the property, make this somebody else's problem, or we're going to hire a bunch of appraisers and assess whether or not the value of the property after we put the easement on still meets their lending guidelines. So you can deal with a best case scenario. I had a matter recently with a very high net worth individual whose creditworthiness was through the roof, and the subordination was the matter of making a phone call, and it took a couple days. It was a private banker out of state, and they said, well, we're not at all concerned about it. On the opposite end of the spectrum are federally insured residential loans. They're insured by Fannie Mae or Freddie Mac. If you have one of those, start early in the easement process to get the subordination. It may not be possible. They may just at the end of the day say no. Or in the alternative, it's going to take a long, long time because their federal underwriters will require appraisals, and they will take a very hard look at the language of the subordination. We're talking months, not days. and it's not necessarily a certainty. I find that in a rising interest rate environment too, it's really, really critical to do it because refinancing is often not an option. If you have a mortgage that's out there at 3.5%, good luck convincing a landowner that they should refinance at 7%. Not going to happen. So that puts you in a position where you really need to work very, very hard with the lender to make them comfortable with the process. So start early. Be cognizant that an appraisal may be required, and particularly where you're dealing with federally insured residential mortgages and deeds of trust, you're not alarm bells, but you should be on the phone with a friend early on to try to figure out what the subordination process is. All right, substantiation and appraisals. The IRS, this is particularly an issue for donated easement. The IRS will require an appraisal for any donation with a value of $5,000 or more. Form 8283. So when you go and file your tax returns, the IRS is going to want a Form 8283. It's a document signed by the land trust saying that, yes, in fact, there was an intent to donate a easement. There was donative intent. As part of that Form 8283, all land trusts, whether it's Scenic Rivers Land Trust, whether it's Maryland Environmental Trust, other land trusts, will want to see an appraisal. They're not going to necessarily second guess what the value is in the appraisal, but they're going to check that it's the right property, that the conservation restrictions are described properly. So the reason I call appraisals a problem area is there are, I think, kind of like lawyers and realtors, appraisers are kind of in the same catch-all, that there's really good ones and there's some that really aren't very good. The type of appraisal you need to substantiate a large conservation easement donation is not the same type of a appraisal that you would get for a residential real estate transaction. This is a very specialized appraisal. You have to start, the starting point is the before and after value. And you would think, okay, well, just, you got 5 development rights at $200,000 a piece, you're eliminating 4 of them, that's an $800,000 deduction. It's not that simple, and the Treasury regulations are much more nuanced and requires an analysis of not only the before and after value of the property that's being donated, or the property in which the easement's being donated, but it also requires you to look at other properties in the neighborhood owned by the same owner or the same family and look at the increase in value that the conservation restriction on property A may cause on property B. So there's a lot of things like that that really is important to look at. And I also always counsel landowners that if you're going to be taking $1 million tax deduction or a $100,000 tax deduction or $500,000, the IRS is going to be looking at this pretty carefully, and you want an appraiser who can testify in tax court. So not to scare people off from doing a conservation easement, but if you're going to do it and you're asking for a $1 million tax deduction, absolutely somebody at the IRS is going to be looking at it because there's been a lot of abuse in the past. As Joan will talk about too, these tax deductions are extremely valuable because you don't need to take them in the first year. You got 16 years to do it. And if you can't use all of it in year 1, you get what's called a 15-year carry forward. So the value of these easements is large, and the IRS is looking at these things carefully. So find an appraiser who knows what they're doing and can testify in tax court if and when the property owner gets audited. Not a big deal, but you want to do it right at the front end of the process, not try to kind of justify things after the fact. Survey and title. Look at title early. This is kind of, real estate 101, but get a title report. Take a hard look at every exception, all of the Section 2B exceptions. Go through every one, look at the document, or look at the individual instruments that are cited in there, and think about it, and take the time to talk to a a title attorney, a real estate attorney, a land use attorney, figure out what all the things are. It's not just a matter of finance liens. There could be other easements. There could be other restrictive covenants. There are all sorts of things that are lurking in the land records. There are district agreements with mouth. There are other conservation easements. There are use restrictions. All of these things kind of need to be considered early on in the process. I'm constantly amazed with regard to boundaries. One would think in this day and age everybody would know where their property lines are. It's not true. There are all kinds of issues all over the place. There are adverse possession issues. There are fences. There are encroachments. There are all sorts of things. There are estate disputes. There are survey gaps and gores. It's, get a good survey early on in the process. The better the survey, the more problems you avoid. And some of this is a judgment call. If it's a property that's been subdivided in the last 15 years, probably a lower risk than a property that's been in family ownership for the last 200 years, with various outconveyances here and there, and various estates that have been open and lawsuits and court orders and things like that. So take a look at title. Let what the title report tells you kind of guide the survey process. And sometimes you don't need a very complicated survey. Sometimes you're going to realize early on in the process you need to get a gold standard surveyor who really understands title issues. Who's the owner? It should go without saying. That's probably the first question. Is the person you're talking to actually have authority to speak for the owner? But it's not always that simple. Estates are complicated. Limited liability companies are complicated. Trusts are very complicated. Things that are tied up in bankruptcy are complicated. Things that are in various states of litigation. If a property is in litigation, you should probably get on the phone with the attorneys handling the litigation early on and say, hey, what's going on with this? I had a property a couple of years ago, not in this county, not in Scenic Rivers, where a client just said, I'm in litigation over this thing, but don't worry about it. Well, should have worried about it. And turns out that it was a question about who had authority over this family farm. And, well, it turns out that the person that was seeking this development approval was in active litigation with his mother and his siblings over who could actually control and make decisions over this family farm. Needless to say, that cost client a lot of time, a lot of money, and the entire deal ended up falling apart. Had everyone been a little bit more careful early on in the process in issue spotting, they would have realized that, hey, we got to get on the phone and figure out what this litigation is all about. So a year later, somebody said, oh, yeah, I think there's a piece of litigation. That was the wrong time to try to fix a problem. All right, retained development rights. As both Sarah and Kristen mentioned, if you are conserving a piece of property, it is absolutely appropriate for the landowner to retain certain development rights, retain the ability to build a house, 2 houses, agricultural structures, access roads, deer stands, you name it. You can negotiate all of these things. The difficulty becomes in deciding where the house goes, just by way of a hypothetical. Telling a landowner you can build a house wherever you want is almost impossible to appraise that, right? And if you can restrict the building site to 1 acre of a 200-acre farm, or 5 acres, or 8 acres, or whatever it is, that makes things much, much simpler to monitor possible encroachments in the future, to work with a landowner so you don't end up with a big kerfuffle over where am I allowed to do things. And it makes the appraisal process so much easier because the appraiser just says, okay, we've got one development right on the waterfront portion of this farm. We're going to appraise the extinguishment of all of the remaining development rights. And it just makes for a nice, clean, simple process, as opposed to we have the ability to build 3 houses somewhere on the farm someday in the future that may interfere with the conservation values. If somebody wants to If the main conservation value is a scenic view shed, either from the water or from a public road, well, maybe putting up a giant house right in the most scenic portion of that is going to interfere with the conservation values. You want to work through these issues ahead of time as part of the negotiation process of the easement. And having kind of loosely defined, yeah, you can build a house somewhere someday in the future of indeterminate size, wherever you want, you're going to end up having problems. So to the extent you're dealing with landowners, property owners, land trusts, have that conversation early on that says, look, let's do some land planning now. Where's an appropriate place for a house? How do we make sure that landscaping is addressed, that we are, addressing the view shed issues, that we're, kind of just do the land planning up front. It's more expensive. Property owners don't want to do that. They don't want to be constrained on what they can do in the future. But in order to have a good conservation easement, it's really pretty important to do that. Corporate issues, this goes back to who's the owner, who speaks for the property. You get comfortable with, if it's a limited liability company, there's tons of limited liability companies out there now. Many of them are being used kind of increasingly for estate planning purposes, where families will set up limited liability companies to, it's much easier to swap out membership interests. Probably figure out, early on, take a look at the operating agreement, figure out who has signature authority, figure out who the members of the LLC are. It's a shocker. Sometimes in families, not everybody agrees with one another. There are family disputes. And particularly where you have these kind of novel estate planning tools, not even novel, pretty standard estate planning tools, not everybody sees, the family farm in the same way. Had a matter recently with 9 kids owning a property. And try to get 9 siblings. For those of you who have siblings or multiple kids, trying to get them all to agree to do something, not an easy thing to do. LLCs can sometimes simplify that because you don't have, in that example, 9 tenants in common. You actually have a structure where you can vote, where you have some governance, where you can, there's a decision-making process. But if you're dealing with an LLC, you got to get in there in the meat of it and look at the operating agreement, talk to the members, figure out, is there a manager, is there a managing member, what authority do they have, and where do they derive that authority from? Same thing in estates and particularly trusts. If you have a property that's titled in a trust, there's a trust instrument out there somewhere that governs who the trustee is, who the substitute trustee is, the facts and circumstances under which they can make decisions. Sometimes there are trusts that are embedded in wills. You gotta do the hard work and read these things, and if you don't read them, I can almost guarantee you that something will turn out badly someday in the future, and you don't want that. When in doubt, consult a professional. I'm not an estate planning attorney, but I know a lot of them, and folks in the community can, pretty quickly recommend Joe or Mary or Bill or whoever specializes in these things to sort through the issues and address them ahead of time, early on. Bankruptcy, this is one of my favorite topics now. I work at a firm that we do kind of half land use and real estate and half bankruptcy. And there's a reason that I choose to work with this firm is that when everything ends up in the toilet in the real estate world, all our clients end up in the bankruptcy world, bankruptcy and insolvency world. I joke somewhat, but bankruptcy is a real issue. The unique feature of bankruptcy is when a property owner or an LLC or whoever the ownership interest is in bankruptcy, they don't get to make their own decisions. They got to go to the court, they got to go to their trustee, they need to get some sort of approval from the federal bankruptcy court to do anything. That's not to say you shouldn't engage with a property owner who is under bankruptcy protection, who's going through restructuring. There are fantastic land conservation opportunities that flow from that, but it is more complicated. But in my world, most complicated things also, there's a tremendous amount of opportunity to do something interesting. We worked on a matter in a bankruptcy a couple years ago. It had been in bankruptcy for years and years and years, and we're able to, get this family out of this protracted bankruptcy with a purchased easement. But we had to go to the bankruptcy court and the trustee and explain why this was for the best thing, not just for the bankrupt debtor, but also for the various creditors. And that's the role of either the trustee or the court, is to protect not only the bankrupt debtor, but also with being very mindful of the rights and expectations of the various creditors to that bankruptcy estate. Land trust can be a partner in that. And as far as hot topics, a year, 2 years, 3 years from now, I think we're going to be seeing a lot more of those types of issues. I guess telling Joan, I've now been doing this for 20 plus years, been through 3 bad recessions, and every time we go through a downturn, I learn something new about kind of the bankruptcy and insolvency world. And it's just a matter of time, and then we're all going to be dusting off our horn books and saying, okay, what's it, chapter 13 versus 11 versus 7? Hot topics. These are things that come up often. It's been really interesting over the last 10 years, 10 to 15 years, particularly with the focus on Chesapeake Bay restoration, water quality issues, forest issues, smart growth. There's a lot of activity in the ecosystem services world, basically restoring properties for profit, restoring streams and having for-profit actors and not-for-profit actors doing stream restoration work, doing forest mitigation work, doing wetland mitigation banking, people looking at carbon sequestration and carbon trading markets. This is a very, very active area. It continues to evolve. It's really interesting. I should say, most of these land restoration efforts, whether they're done in the private sector or the public sector, ultimately result in having some kind of a conservation easement. That is not that is a regulatory easement. Whatever governmental entity is supervising that, they require it. But we've had a lot of property owners who say, well, we've got 200 acres. We want to do stream restoration over here. We want to do forest mitigation over here. Can we do a donated easement on the balance of the property? And the answer is, yeah, maybe, but be really, really careful. And where you are having a development project, whether that's a green development project or a more traditional development project, you need to be very, very careful if you're also trying to pair it with a donated conservation easement. If you're building a Walmart over here and you're putting a conservation easement on the back 40, and you're going to take a tax deduction in particular, the IRS is going to be looking for that quid pro quo type of a transaction. It's really no different if you're doing a $5 million stream restoration over here, and then you're taking a $1 million tax deduction for a donated conservation easement on the back 40. Just because you're doing a green development project for profit does not mean that it's not a development project. In my mind, a development project is a development project, whether or not you necessarily agree with the outcomes. Quickly on the carbon sequestration issue, it's a really interesting issue. It generates a lot of chatter. I will tell you, in Anne Arundel County, land values are such that, as currently out there, the value of carbon credits is probably not all that much, because what's being, driving the value of those carbon credits is 10,000 acres or 100,000 acres of boreal forest in Canada at $500 an acre or $200 an acre, not ag land in Anne Arundel County at $10,000 an acre or commercial land at $1 million an acre. Really rough numbers here, but that's having a $100 an acre carbon credit is insignificant when you have ag land values at $10,000 an acre. So it's interesting. Anne Arundel County, Central Maryland, really the entire state, land values are relatively high compared to national and global land values, and it makes kind of carbon sequestration issues a little bit more difficult to really get a lot of purchase in a valuation, from a valuation perspective. The other reality in Anne Arundel County is parcel sizes are relatively small. If you can probably count the number of privately held parcels greater than 500 acres on probably your fingers and toes, probably less than that. Yeah, it's not like you're out west dealing with 50,000 acre ranches. You have relatively small parcels, which also means that they have a lot of neighbors and a lot of different opinions about what should and shouldn't be done. It's a great place to be a land use attorney. It's a little difficult to do landscape level land protection, and particularly kind of purchased easements and kind of landscape level restoration being funded by county, state, and federal partners. It's more difficult to do it. It's not to say that it can't be done, but putting together an assemblage of different properties to get to 1,000 acres, to get to 5,000 acres. Scenic Rivers has done it very successfully. It's probably the leading land trust who's able to do it in the county. It's just more challenging here, just given the relatively smaller parcel sizes. I think this is my last slide. Estate planning, generational wealth transfer, 1031 exchanges, donated conservation easements or purchase conservation easements can be a critical part of estate planning, particularly for high net worth individuals. We are in the middle of a massive generational wealth transfer, with older generations having trillions of dollars of value that they're passing on to younger generations. A lot of that is highly appreciated real estate, and several times a year I get questions about whether or not conservation easements and proceeds from purchase conservation easements can be used in what's called a 1031 like kind exchange. I will say talk to Joan. 1031 exchanges are difficult. They move very, very quickly. They are areas that are ripe for all kinds of problems because you have when you're doing a like kind exchange, basically you're taking your tax basis in one property and moving it over to another property. So in a typical scenario, you sell a appreciated piece of real estate you purchase it for $100,000, it's worth $1 million. In order to not pay capital gains on the $900,000 difference, you take the proceeds from that property, you take that $1 million, and you buy another piece of property. You get a carryover of your basis, your $100,000 you purchased the first property for, and you get it in the second one, so you defer capital gains taxes. When you're dealing with conservation easements, that gets really, really tricky, and you need a very, very good CPA and tax accountant, if not a tax attorney. And that's one of those areas where I will just redline that and say I'm not getting anywhere near it because it's too complicated and it's way beyond my expertise. So this is definitely one of those phone a friend and be prepared to have not phone a friend, but probably pay a friend to get the right advice, because you don't want to get it screwed up, and you only have a very limited window in which you can do that. And if you miss the window, you can't transfer your basis, and there are massive tax implications. So, on that, Joan, it's all yours.
Thank you. Magic clicker.
That's right.
So a lot of this has already been covered kind of high level, but still want to go over some of the topics that we briefly discussed. So some of the tax savings, because there are. So I think Ben referenced that you can get a charitable tax deduction, which is part of your Schedule A as your itemized deductions on your federal income tax. It is subject to 50% of your adjusted gross income. So, you can't write off all of your income, but as Ben referenced, if you don't have enough income in year one, you can carry forward for 15 more years, so you can spread that out over 16 years. Sometimes if you're doing good tax planning, and say you have an event that generates a lot of taxable income in a year, you try to maybe, so your adjusted gross income will be high, you maybe try to mirror and time that tax, your conservation easement to happen in the same year, so that your income level is high and you would get your deduction in the same year. But if not, and you can't do that, then you do have 15 years to do that. So there is one special little nuance rule for your qualified farmers and ranchers. They are not subject to 50% of their AGI. They can write off 100% of their AGI using a charitable donation of a conservation easement. So you can just see that with the landowner, with the example that I provided, with a person who makes $50,000 a year, or their adjusted gross income is $50,000 a year, it will take them the full 16 years to get the benefit of that deduction. As your rancher who gets 100%, they get it in 8 years. But just that's the high level of 50%. You don't get to write off everything in 1 year. You do have on the Maryland side, your federal itemized deductions automatically carry over to your Maryland itemized deductions. That's kind of your starting point. Maryland does have an income tax credit, which is usually more advantageous because a credit is dollar for dollar against a tax liability, where a deduction, you then apply the tax rate to it. So say 8% in Maryland. You can't get both in Maryland. You can't take the deduction and get a credit. It's or. So you can take the itemized deduction, include your charitable deduction in your itemized deductions, or you remove it and you take your credit. Typically, as you can see, my example is that it's better to take a credit because you are going to get more. So again, as we've talked about, the credit is equal to the value before versus the value after, which is what Kristen talked about, how you determine the value of this easement. And so then with Maryland, it's the less, you can get a maximum of $80,000 of a credit. So it's $5,000 or $10,000 a year if you're married filing joint, and you can have that for 16 years. So you get a maximum of an $80,000 income tax credit for Maryland. And that's different. So here's a little bit of the bigger example. So kind of before your value before the easement, 800,000 value after because you've given up some of your rights. Here's your contribution, your donation. For federal income tax, I had to pick a tax bracket. You would have tax savings of $132,000. That is, over maybe 16 years, or it could be over 1 year, depending upon your individual circumstance. And then if you look down at the state, you can have either $32,000. This is where I was talking about the deduction only gets you 8% of that deduction versus the credit, which is $160,000. Because again, $80,000 per person, $160,000 for married filing joint. So again, where the credit is more advantageous at the state level. We've kind of heard this already, but you can't say it enough. Pay your friend. For this matter, this isn't your payer. It is important. And there are, as you've heard, very strict rules. The IRS does look and watch. So to be careful and to make sure you have your proper documentation. You have your very highly qualified appraisal done. One important rule here is the timely appraisal. It must be completed within 60 days of your easement. So it can't be an old easement, or excuse me, Aaron. It can't be an old easement. It needs appraisal, excuse me. It has to be signed by everybody. You've heard all this one, and get yourself a qualified person to help you do this one. there's some other added benefits. We all pay state property taxes on our property. You can have, for 15 years, no state property tax on the property under the easement. So, it doesn't include the house or the other ancillary property that might be included in your total parcel. And Anne Arundel County does have some tax credits for your real property taxes. You do have to apply for it. It's not an automatic, and you do have to apply every year. But there are, not just federal income tax, but you have your state and local real property tax advantages to doing this. Because again, if you think about it, the value of your property has been reduced because you've put some different restrictions on it. Real quickly on the, as Ben was kind of already talked about briefly, how you do have estate issues, because again, the value is being reduced because you've given up your rights to do things. So here's an example of, your estate and gift tax exemptions. If you have assets over, most likely now we're looking at 23, you wouldn't be able to get something done in 22. So if you have a taxable estate, so you have something over $12,920,000, and you are able to reduce that value, the highest estates are at 40%. So, it can have real dollar impact to somebody with an estate that is taxable. So as I said, if you have a $2 million reduction in your value, that's $800,000 of estate taxes if you have a taxable estate. This is your really high worth net people. And again, as you've heard, everybody's tax situation is different. You have to seek advisors that know your client's personal tax situation. There's not a one answer fits all, because it really does matter what else do you have, what's happening in your portfolio. But we are here to help you, and we are your partners, and we can help you. Not on tax planning, though. We'll help you with the conservation easement part of it. So we're going to go back to Sarah, because she finds clients millions.
Okay, well, thanks, Joan and everyone. So, I'm just going to run through some of the most common funding sources in Anne Arundel County and do 2 examples for my favorite program. So this is the Forestry and Forested Land Protection Grant Program for Anne Arundel County. So it's a mouthful, but it's a really good program because it's one of the few ones that actually can protect land under 50 acres in the county. So this is run by the Chesapeake Bay Trust. It's managed by the Chesapeake Bay Trust, which is a great grant managing nonprofit. And it's funded by Anne Arundel County. So there's 3 tracks in here. It's all, as you can tell by the title, it's all about protecting forest or creating new forests. And the big focus is on planting trees. So there's 3 tracks. One is planting trees on already protected land. That's not so common. Protecting forested land, and my favorite is protecting land and also planting trees on it. So, if you have a forest field combo, you can protect the forest and also plant new trees. So, for the money, this gets a little complicated. So you have this base rate where if you're not getting an appraisal for a property, you can the grant program can pay $2,000 per acre of existing forest. And if the landowner is willing to let us plant trees, it'll pay about $5,000 per acre to the landowner to let us plant trees. And then the grant program also pays for the planting of the trees, all the due diligence that goes with doing the conservation easement, if it's a higher value conservation easement, so say you're giving up a bunch of development rights, you can get an appraisal that has a higher value per acre, so say $8,000, but you'll just need an appraisal to back that up, and also cross your fingers that the funding program has enough money to actually pay that out, and that you're competitive against other grant applications. So I'll just go through 2 examples. So one is Lewis. So he has 40 acres, half in forest, half in field. He already has a house, that blue little square right there. And, it's zoned RA, so maybe he has one more development right, but he doesn't want his entire property in a conservation easement. So easements don't have to cover their entire property. So we're going to exclude his house and 5 acres around his house. Just peace of mind. He doesn't want anyone telling him what to do with his house, which is not uncommon. So, we're going to protect the 20 acres of forest and 15 acres of field. And he realizes that he can get paid more for this conservation easement if we plant the field with trees. Because, again, this grant program only pays for forest. So what does this grant application look like? We're going to ask for $2,000 per acre for the 20 acres of forest, so that's $40,000, because we're just not going to get an appraisal for this one. And then we'll also ask for $5,000 per acre for the 15 acres of trees that we're going to plant. Then we'll, of course, ask for money to do all the due diligence and cover our costs. So in the end, Lewis, the landowner, receives $115,000 for his conservation easement, and his only cost is about his legal fees, which I'm just throwing out a number of $1,200, but who knows? It depends on what your lawyer charges. So a second example, which is also common on how we do these grant applications. So for example, Lauren has 100 acres, 70 in forest, 30 in field. She doesn't have a house yet. It's zoned, so she has 5 development rights remaining, so she could build 5 houses. But she wants to retain, 1 development right because she wants to be able to retire on this property later. So we're going to carve out, not carve out, but create a building area, so that blue area. So it's just a couple of acres. She's not exactly sure where she wants to put her house, but so we want to give her some space in case somewhere doesn't perk exactly. She can move it to somewhere else. And we're going to place it in the field because we want to protect the conservation value of the forest, because this grant program is for protecting the forest. So since she has so many development rights to give up, she has, her appraisal says that, or our appraisal that she paid for, says the easement is worth $800,000. Now, like I said, this grant application only pays to protect forest. So we have to, kind of do some math here. So $800,000 divided by 100 acres is $8,000 per acre. So 70 acres of forest times 8,000, we can pay her $560,000 through this grant program, again, if the funding is there. So then we cover all of our other costs, and she receives $560,000 for her conservation easement. So this is a bargain purchase. So the easement's worth $800,000. She gets paid $560,000, and then her charitable tax deduction is $240,000. So you can see how that works. So she can also apply for the tax credit, and she can get some reduced property taxes. In Anne Arundel County, it only is for donated portion of the conservation easement, so kind of have to do some more percentages there of how much you can get your property taxes reduced. And just a couple of other additional funding programs. So the state actually has a lot of really wonderful and well-funded programs for conservation right now. They all want over 50 acres. So stateside program Open Space has a ton of funding right now, and it's fantastic. They also they're focused on big properties. They have the entire state to cover. And they're also looking just for, certain areas. They're called targeted ecological areas. So that's up on the web. You can find that. I can also find it for you. And there's also a really wonderful agricultural preservation program for Anne Arundel County. So this is run through the county. Barbara Polito's great. Billy Gorski is also there. I can put you in touch with them. Again, 50 acres or more, and also specific on where they're going to protect. So that program is to preserve the agricultural culture of the county, and so they're focused on South County, where agriculture is really strong. So you need it in the Rural Legacy Program area to be able to qualify for their programs. And there's also, you may have heard of the Readiness and Environmental Protection Integration Program with the DoD, but we all call it REPI for short. And that is very specific in Anne Arundel County. It's just around the Naval Academy base and Greenberry Point, and what they're looking for is to either provide public access or promote resiliency for the base. So very, very specific on what they want to achieve with their conservation funding. And last is the Forest Legacy Program. So this is run through the U.S. Forest Service. And this is basically they're looking for large acreage because we're competing on a national scale here. So Anne Arundel County, poor Anne Arundel County, is also trying to compete with rural lands in Georgia and Idaho. So we're looking for that. To be competitive, you need at least 100 acres to apply. And we can work with the Forest Service through DNR to try and put together an application. And I think that's it. So we're right on time. I'm so proud of us. So now we have questions. Does anyone, questions for any of the speakers or just, you know, conservation in general?
Scenario one, you've got two properties in separate ownership. Property one, you got a house up top of the hill looking out over property two. In that scenario, with property two not being preserved, the undeveloped view shed increases the value of property one. If it were to be developed and turned into a giant warehouse project, it would diminish the value of property one. If it's under common ownership, although putting an easement on property two would devalue that property, the lack of those future development rights on property two would increase the value of property one. So when they're under common ownership, the IRS wants both of them appraised. So that's not always the case, but I mean, there is a hypothetical where the other properties would increase in value by virtue of having the open space or view shed protected.
And is there like a limit to that surrounding properties? Is it within view or X amount of miles or just the same road or something like that?
I think there is guidance, but I don't know the answer to that. Do you know, Sarah or Kristen? Yeah, off the top of my head, no. There is an answer, and there is some guidance somewhere, either in statute, regulation, or maybe some treasury guidance. So.
Appraiser should know. Yeah, leave that up to the appraiser is my advice. But usually we're dealing with a property that's literally adjacent to the next one, and that's where it really, really starts to matter. Any other questions?
Is there a benefit to the landowner to doing restoration or any sort of land improvement prior to the conservation easement process? Would that increase the value with an appraiser coming in, or better to not touch it?
Yeah, so the question is really a question of phasing. You know, if you have a property, is it better to do some restoration work ahead of time or kind of coordinate it with the easement? If you're planning on donating the easement, it removes the specter of a quid pro quo transaction. So having them not at the same time simplifies things because you can much more credibly take the position with the IRS that the for-profit stream restoration work was absolutely done completely independently of the donated conservation easement we did 3 years later. If you do them at the same time, or if you are doing a traditional development project at the same time that you're doing a conservation easement, you just need to be very, very clear that they are not tied to one another, that they are not in any way, one is not in exchange for the other, particularly not in exchange for some governmental approval. If you go to the county and say, hey, I'll donate, I will proffer to a conservation easement on the back 200 acres if you allow me to put up 500 townhomes in the on the front of the property, guaranteed that is not going to pass muster with the IRS.
So also, most conservation easements that are written today allow for stream restoration and conservation to happen after the conservation easement is in place. So if there already is a conservation easement, usually they're not going to stop a restoration project from happening unless there's some language in there that's keeping that from happening.
Yeah, I was thinking more, kind of upping the value of the appraisal.
Yeah.
Down the road.
Anyone else?
I would think that in answer to what you were asking, we'd want to look at what would be the impact, say if you had agricultural land, whether, say, planting trees might in fact decrease the productivity or the assessed value of that agricultural land. It might be worth less, I don't know, as being able to till it versus planting trees on it. And of course, the value for forestry might have to be looked at over the course of 20 years or something like that, because you're creating the potential maybe to harvest it in 20 or 30 years. So obviously that's a question for an appraiser.
Mm-hmm.
That and maybe the folks from the DNR Forest Service.
And NRCS usually has a rate, a value per acre for cropland versus forested land versus other uses. So you might be able to look that up to try and figure it out.
The difficulty, the appraisal problem, I think, is appraising emerging ecosystem services markets and what you can do with a property. 15 years ago, nobody would have anticipated the volume of stream restoration work. 10 years ago, nobody was talking about carbon sequestration. So finding an appraiser who can not make too many extraordinary assumptions with regard to the value of those types of ecosystem services, for sale ecosystem services, it becomes very, very challenging. And most appraisers will take a very conservative approach and say, I'm not touching that. Like, I know what the timber value is. I can appraise timber value. I can appraise row crops. I cannot appraise the value of carbon sequestration or the possible future stream restoration. It's just very, very difficult to bake that into an appraisal.
Any other questions?
Do you know what the percentage of the funding that's in the Anne Arundel County Forestry and Forested Land Protection is from Forest Conservation Act versus from critical area fees in lieu?
I do not know. Brittany?
I believe it's about half and half.
The reason I ask is that apparently with the 5 million trees legislation that was passed this past year, that there's a now prohibition on purchasing easements on forested land. Did you hear that? This one was a complete,
I think I can answer that.
yeah.
It's actually two separate issues. I think what you're thinking about is there's a bill that passed the General Assembly session 2 years ago that prohibited the recognition of forest mitigation banks by preserving existing forest. Basically mandated land conversion from basically tree planting to get credit under the for a forest mitigation bank for Forest Conservation Act purposes.
Exactly.
So that's not tied to the 5 million tree, I didn't think, but
I didn't think so either. I understand what Ben just said. So,
Okay.
yeah.
Yeah.
Planting 5 million trees, I think, is just trying to get trees in the ground.
Yeah. There was something that recently, an article in Calvert County discussed how they couldn't do purchase development rights using the fees in lieu from forest conservation. So I was like,
that's interesting. I mean, that kind of goes into their TDR program as well. But I would think that if the state, and there's an Attorney General's opinion about this about 2 years ago, that basically said preserving existing forest is not a way to, you can't generate mitigation credits that way. And similarly, using funds in the county's TDR program to purchase easements, I would think would also violate that AG's decision. I think. So.
area I guess I need to look at, although I'm not involved in
Yeah, I was like, why are you worried about that, John?
well, because I had a landowner asking whether he could sell a easement on his existing forested land. And it's like, well, okay. I thought initially that it would be fine because there was no prohibition in his existing forest or existing conservation easement. But then I'm like,
Well,
I better
although
look
you
at
can't
this up.
you can't do a mitigation bank that way, you may be able to, the landowner might be able to sell a conservation easement to a developer who needs off-site mitigation credits, or not credits, basically needs to do off-site mitigation. So you can't recognize the credits in a bank, but you can still do a direct easement, I think. So.
There's also the possibility if, that the county ag woodland program is woodland too. And, because the ag side, he has to be over 50% ag, cropland. But if it's a woodland property where the majority of it's woodland, then he can go to that program too. Of course, you have to have a site index report and all that stuff. That's a possibility.
All right, any?
On Michael's question, in this conservation easement handbook about the enhancement, it says appraisers need to pay careful attention when an easement encumbers a portion of the land owned by the donor or the donor's family, or when other land may be enhanced or increased as a result of the easement. If the easement covers a portion of contiguous property owned by the donor or donor's family, the value of the easement is equal to the value of the entire contiguous portion before the easement minus the value of the entire contiguous portion after the easement. But regs also require that the appraiser consider enhancement of any property, whether or not contiguous, owned by the donor's family, or related parties. And that's a defined term in the regs. It doesn't have to be contiguous. Be farther away.
So I guess that might count for scenic view sheds, perhaps. So if you have a property far away, but it's looking onto a valley, that just got protected. It might be a mile away, but
That's why these appraisers or appraisals tend to be fairly specialized. It ends up being a judgment call for the appraiser.
I wonder if some of the adjoining land was owned by an LLC in which family members were
Conservative
members.
approach is absolutely appraise that too. Yeah, good appraiser.
Oh, Lord.
anyone else? Last call. All right. Well, thank you so much for coming and hanging out with us this morning. I hope you all learned something. And please contact us with any questions. We'll be sending out the slides later in an email. So, and a survey to see how we did. So, all right. Thanks all.
Thank you.